Hello, everyone, and welcome to the lecture series for the preparation of CLAT examination. In this particular lecture series, we are taking the legal reasoning portion of the CLAT syllabus. And so far, we have completed the major subjects like the law of contracts, the Indian Penal Code, the criminal law, and we have started with the Constitution of India. And we have partially completed the Constitution of India, but the rest of the portions will be completed in the upcoming lecture series. Why I have deviated from the Constitution, I have opted for the law of tort. Is because law of tort is perhaps a very small portion of your legal reasoning area, and it is important to understand the law of torts so that it becomes easier to get quick marks in your competitive examinations without spending a lot of time in studying and understanding a particular topic. So law of torts is confined only towards around 12 to 13 topics that has to be covered, subcategories of tort with that has to be studied for your syllabus of CLAT competitive examinations. We'll be dealing with what exactly is tort, why is it so necessary, and whether it is actually applicable in the uh, Indian society as such or not, from where it has been taken, what type of law actually deals with it, and where do we find mention of these torts in our Indian law legal fraternity. So whether there is an act that has been instituted or there is a superficial composition that has been embarked in the different laws that has been created, or there is a chance of improvement in this particular tort, to what extent the tort is being applicable in India, and how the judiciary is going to make sure that if there is any tort that is happening in the society, how we are ensuring that it does not infringe or take away any legal remedy or legal right that has been provided to the citizens of India. So first and foremost, we need to understand that what exactly is tort. We'll be starting with that. And after completing this particular video, you will be able to understand that what exactly the tort is, what are the categories of torts, how many types of categories of torts are there. We will be talking about the general defenses that can be used against the law of torts. So, taking into consideration all these things, it becomes perhaps very important for the CLAT aspirants to have a quick knowledge and quick grasp of all the essential topics of the law of torts. So with this, let's start with the video. I suppose the screen is pretty much visible to you. The first and the foremost question that comes up in front of us while discussing tort is, what exactly is torts? What exactly is torts? And we'll try to understand this particular topic. What exactly is torts? I'm just checking whether the pen is working or not, so that you people can see whatsoever I've been writing. Okay, so when we talk about what exactly is law of torts, the first and the foremost thing that we need to understand here is that it has been derived from a Latin term. Okay, it has been derived from a Latin term which means twisted or crooked. And that Latin term, with what I'm talking about, is it is tortum. And somewhere it is also mentioned tortoise. So if anywhere you find mention of tortum or tortoise, it specifically means law of tort is being governed, and it means twisted or crooked. So if in a society, there is any wrong, if there is any wrong, okay, so let's understand is that in the society there is a wrongful act that happens, wrongful act, and because of that wrongful act, there is a legal damage. That it means that the society recognize it not essentially just as a moral wrong, but it is considered that it's some sort of right has been infringed or some damage has been given, and that damage is being recognized by the law itself. And then when that particular damage is being done, then there is a remedy, a legal remedy also available for the same. So these important points is the main source that whenever there is a wrongful act, there should be a legal damage, and if there is a legal damage, then there should be a remedy for that legal damage that has happened. So these essential points constitute what exactly the tort is. Tort, if you can see the screen, tort is a civil wrong. Okay, it is a civil wrong. That wrong is based on the breach of duty. If somebody has been given a particular duty that they has to do it, but they are not doing it, then it is considered as a breach of duty imposed by a law, which breach gives rise to personal civil rights. Okay, so there is a wrongful act. That wrongful act is giving, there is a legal damage because of the wrongful act, gives rise to personal right of action for a remedy not exclusive to another areas of law. Okay, so not exclusive to other areas of law means that there are chances that some of the torts that you might find mentioned in this lecture, you might feel that this particularly is also an offense in the criminal law. So it is not exclusive to another areas of law that it is going to be governed. So in India, since we have taken the law of torts from the common law, so there are chances that you will find overlapping concepts. Some of the torts you will find mentioned in the criminal law. For example, defamation, negligence, mischiefs. When we will be discussing about these torts, you will find references of those concepts which we have already covered in Indian Penal Code. Then you might have this particular confusion that why is it needed to study in the law of torts, and why is it not that we have already studied in the Indian Penal Code? Then how exactly is the difference? There is a difference. The difference is when we talk about Indian Penal Code, what we are assuring is that there is an offense that has been done. Okay, so in Indian Penal Code, we are talking about offense, but when we talk about law of torts, it is a civil wrong. So it is a civil wrong. So when we say that it is a civil wrong, it means that the damages that has been accrued will give rise to remedy. And when we are talking about remedy, the damages is compensated by unliquidated damages. So that assures that whenever there is a civil wrong and there has been a damage that has happened, then the remedy is unliquidated damages, unliquidated compensation. Not damages, I'm so sorry, but it is as a compensation. So because it being a civil wrong, we will be compensated in such a manner that it ensures that the person who has suffered that particular damage should be thoroughly compensated. And that is what is the main crux, the main idea of tort is. So sometimes you will find an overlapping concept in the civil laws and sometimes in the criminal laws. The reason for the same is you will find nowhere any such legislature that has been created for the law of torts. Like for criminal law, you have Indian Penal Code, CRPC, Code of Criminal Procedure, you have Evidence Act. But and we talk about civil laws, you have the Code of Civil Procedure, and you have Law of Contracts, you have Sales of Goods Act, you have different legislations which are being governed through the civil laws. But when we talk about tort, so we don't find mention of any legislature that is being helping us in governing the torts. But it has been amalgamated and has been superficially mixed up with a certain portion of the criminal law and certain portion of the civil laws. So whenever there is an offense when you will find mention of nuisance, when you find mention of damages. So the chances of the person getting compensation is not through the offenses that has been mentioned, the fine that has been mentioned, but rather through the law of torts, that is the person getting the revenue or the compensation for the defamation. So you must have seen different instances in the real world society where you find mention that there are people who have been defamed and they have asked for a thorough amount of compensation. So that thorough amount of compensation, for example, there was a recent case of Salman Khan, and he had accused Mr. KRK for being defamed, and he had asked for a compensation of more than 2 crore rupees from KR Khan, Kamal R Khan. So that type of compensation is never been mentioned in the criminal law. Indian Penal Code never provides you that sort of compensation. Then why is it so that Salman Khan has actually asked for the compensation? It is actually because of the law of torts, that since there was a breach of duty, the duty was not to defame any person. And after that, because of the defamation, there was damage to the reputation of the person, and there needs to be a remedy, and that remedy was provided in the form of compensation, and that compensation was amount of 2 crore rupees that was to be given. And then obviously the case never got forward. But this is how the torts expresses in the Indian society, that it provides compensation and it provides remedy beyond the criminal concepts and beyond the fine, so that the person who has been the victim should also be compensated. Because when we talk about the Indian Penal Code, when we talk about the criminal laws, they are actually punishing the person who has done any offense. But how the person, how the victim has to be compensated and brought to that particular level is something that is being governed through the law of torts. So law of torts is a common law concept, as I've just informed you. And the common law concept has been derived from the English laws. So from English, we know that India was being governed by the Britishers for quite a long period of time. So there were many things that we have incorporated from them. Some are good, some are bad. And the good things that has been provided and which has helped us out and is still being governed in the Indian society, that is obviously your torts. So I suppose it is understood that what exactly the tort is. Let's try to understand what exactly is the difference between a tort and contract. So first and foremost, the question is, I would like to tell you here, and this has been a question that has been asked by people in your competitive examination. So whether it is tort or whether it is torts. Question is whether it is tort or whether it is torts. So this question has been answered by Salmond, and we will eventually be discussing it. But for your better knowledge and understanding, I would request you to, after seeing this video, you try to research over this and try to figure out what exactly is, whether it is the law of torts or whether it is a law of tort. So tort or torts, this is a sort of a assignment to you that you will be going forward and you will be finding. And the reason for you to go through it is so that you can be curious to understand. And once you have that curiosity to understand a particular topic, then it becomes perhaps easier to grasp that topic and to retain it for a longer period of time. So obviously, it has been proven that self-study and self-understanding of the topic helps it for a longer period of time of retention, rather if you have been understanding the topic by somebody else. But any which ways, that is another topic of discussion. We are not moving forward in that direction. But this is the assignment that you need to work upon. So let's come to the point of discussion, that is the difference between the tort and the contract. So court will award damages in a contract case to restore the injured parties to where they were before the breach occurred. Okay, but in tort, a court will award damages to compensate the victim for their loss also. Yeah, and are you able to understand the difference? Here, the injured party will be given compensation to a limited scope. But when you talk about tort cases, the court will award damages to compensate the victim for their loss also. So whatsoever the loss has been occurred, that also will be compensated through the law of torts. So this is a very important difference that you need to understand, that if contract case is there, if there is a contract, then the amount of damages is already been mentioned. So that amount is fixed. So it is if the amount is fixed, it is known as liquidated. Because the amount is fixed, so you know what exactly will be the compensation that will be given to you. But when we talk about law of torts, the compensation that will be provided to you is unliquidated. So depending upon the facts and circumstance, your amount of compensation shall be decided. I suppose now you have a clear understanding at what is exactly the difference between a law of torts and law of contracts. But here we need to understand that they have similarities also. The similarity being both the law of torts and law of contract are actually providing compensation to the victim, to the injured party. So we need to understand the difference also, and we need to understand the similarities also, because when the competitive examinations, the questions will be there. The questions will be in such a form that there will be a particular topic that will be given to you, and you have to apply. It will not be differentiated on the basis of contract or the basis of Indian Penal Code or on the basis of tort. But there will be amalgamation of all these things, and there will be a factual question that will be put in front of you, and you will have to figure out that whether it is being governed through the contract laws, whether it is being governed through the tort laws, or whether it is being governed through the penal codes. So for that, you need to understand what exactly is the difference between these laws and what exactly the similarity between those laws. And since tort is actually a superficial concept over both the criminal laws and the civil laws, so that is why it is important to understand how they are related. So this is why difference is there, and obviously we will be moving forward with the similarities also. So I suppose difference between tort and contract is clear. The main difference is that in contract you get liquidated damage, amount is fixed. Unliquidated damages in tort, which is not fixed, both are providing compensation. Yes. So let's move forward. Now let's try to understand another difference between tort and contract again. The distinct difference between contract lies in the issue of consent. So in the law of contract between the parties, so it is obviously pre-decided that what will constitute breach. So whenever there is an agreement that will be formed between the two parties, and whether it is written or oral, they will obviously decide that, okay, for this particular action, if this has not been done, then you will have to provide me this amount of compensation, or you will be reverting back the sum that you have been paid to you. So the issue and it all lies between the issue of content. In contract law, both parties must enter into an agreement. There must be an agreement. There must be consensus ad idem that we have discussed in the law of contract, which says that if there is two parties, there is a meeting of the mind, and they both have entered into an agreement voluntarily, knowingly, and without coercion. Without coercion, if they have entered, there is a free consent. There is a free consent, there is a knowledge. I suppose you must be able to remember section 10 of Indian Contract Act 1872, which provides us with the essentials of the contract, essentials of the valid contract. And in that essentials of valid contract, we have studied that there must be parties who must have entered into an agreement without coercion, that is with free consent. and the party should be competent to contract, and there should be meeting of minds. Yes, that is what we have studied, meeting of minds. So our concept of contract is here, the issue is predetermined. But when we talk about torts, so each party must consent to the contract and its outcome. But in torts, the interaction between the parties is not based on consent. It is not based on consent. Now you would be a little bit confused. I'll try to explain you this particular concept. That, for example, if there is an agreement between a person who is, let's take an example, a shopkeeper and a customer. The shopkeeper and a customer had an agreement that they will be, shopkeeper said that, yes, I will be selling my product to you if you are willing to pay me 12,000 rupees or 13,000 rupees for a certain amount of thing. And if the shopkeeper is not able to make that promise possible, then he will have to pay a certain requisite amount of money. And that is being agreed by both the parties. Okay. But when you talk about law of torts, there is no pre-existence of consent between the parties, but it is through the principles of fairness, through the principles of natural justice. If you have remembered, the principle of natural justice that was recently discussed in while we were discussing the Constitution of India, that there should be fairness. And if somebody has done something which has given rise to a remedy for for not able to exercise the rights that has been given by the society, that particularly person has to be compensated. And here the consent is not necessary. For example, let's talk about defamation. So defamation is something when you make any derogatory statements about someone which is not true. Derogatory statement about someone which is not true, and that publication is, and you speak it in front of public, or you denote it, or you show it in front of public. So if these three things are there, then it will amount to defamation. So whether there was any consent between two parties, consent? No. The answer is no. So even if there was no consent between the parties and the other person has said anything, it will amount to defamation. And defamation is a tort. So defamation being a tort, if you can understand that there was no pre-existence consent between the parties and then only will be compensated. Whomsoever defames any person, so that person can ask for compensation through the law of torts. And there will be obligations, both criminal, because it has been mentioned under the criminal law also. Defamation is there under the criminal law. So the person who has done that particular act will obviously be punished for defamation because it is a crime also. And also the person, the victim of defamation, will be thoroughly compensated because of the presence of law of torts. So this is how, even if it has not been mentioned, but since there is a pre-existence determination of torts, superficial concept that has been applicable through the jurisprudence of the law, it becomes essential. It becomes very important topic to be discussed, because this is how, by understanding the different type of torts and what are the different defenses that has been available for these torts, you will be able to get a better understanding of how the person who has been the victim can be thoroughly compensated. So one is, when you talk about providing justice, one is punishing the offender, and the other is providing sufficient remuneration and compensation to the victim. So both has to be maintained so that there can be an equal justice for both the parties. Obviously for the society also, by punishing the person, what we are doing is we are providing justice to the society. But by compensating victim, we are providing justice to the person also. So the criminal laws are actually, obviously we have studied that whenever there is a criminal action, it is against the state. So the person needs to be punished. It is against the society at large. But when we talk about torts, it is something that has been done to a particular person, or that particular person needs to be compensated. So that is what is the difference between the law of torts and obviously the criminal law, and that we have studied what is the difference between the law of tort and law of contract. Usually torts occur by the intrusion of one party to another that result in some type of harm. So there is an intrusion, there is a private space. So private space, and in that particular private space or ownership, the better word would be ownership of a one person, and that has been intruded. There is an intrusion by another party which caused some harm. Example could be trespass. So if you see, when you talk about trespass, there is a land which has been owned by a particular person, let's take A, and B, without the permission of A, enter into the area, the premises of A. Now this particularly is termed as trespass. And if that particular person enters this particular land without the consent of this A, he has done a tort. He has done a tort. And A, if he finds reasonable ground, he can, and he has been, there is a damage. That is a damage that has been occurred to that particular person A, then B has committed a tort and A will be compensated for that particular loss whatsoever has happened because of the intrusion of B in the property of A, which is known as trespass. So that is what the difference is. Usually tort occurs by the intrusion of one party to another that results in some type of harm. But when you talk about contract, there is no such intrusion. There is a prior agreement, prior consent between the two parties that this is how we have to deal this particular scenario, and after that particular consensual, there is a consent that has been given. If the promises are not being kept, then only there will be a breach. But here, there is no such promise, there is no such consent. Just because one person has suffered a harm because of the action by the intrusion of the other person will be the offender, obviously, and we will be asked to compensate the other person because of the loss that has occurred. Now, there is a difference between the crime, the law of crimes, and the law of tort that we have already discussed. Let's try to summarize it so that it's better understandable for you too also. A crime is a public community wrong. That is, we've discussed that it is against the society as such. That gives rise to sanctions. Sanctions means, what is sanctions? Sanctions means in a specific code. So punishment that has been defined in a specific code. In regards to India, it has been mentioned in the Indian Penal Code. But a tort is a private wrong. Civil, private wrong. Civil, private wrong. The action in the criminal law is usually brought by the state or the crown. In India, we have talked about the state or society at large. That is what we have studied, right? Tort actions are usually brought by the victim of the tort. Okay? By the victim of the tort only, the tort actions can be used. It is not like that anybody can ask and come and say that this particular person has been injured and you need to provide compensation. It should be the victim by himself. But the principal objective principal objective in criminal law is punishment. So, if there is X person who has committed an offense, and maybe that has been defined under the IPC, and if it has been defined in the IPC, it is against the state. So the law says that if X has committed an offense, any person can file a complaint and should produce evidence to show that X is offender. So here there is any person. So it can be the victim also. It can be an anonymous person also. It can be police also. It can be judiciary also. So anybody can file a complaint if there are reasonable grounds or evidence to show that X has committed an offense against X. But when you talk about law of torts, it is only the victim. It is only the victim who can demand compensation. But when you talk about criminal law, the punishment can be, the punishment is there, the compensation is there, but punishment is there, and the punishment can be given if at all there is any complaint which has been filed either by the victim, either by an anonymous person, or by the police, or by the judiciary. Any person can file a complaint, and if it has been proved by the mediums of justice that there has been a crime, then that particular person will be compensated, and there will be punishment also that will be given to that particular person. I suppose these things are very much clear to you guys, and let's move forward and let's try to understand. We have already summarized what exactly is the difference between a tort and a crime. What is the difference between tort and contract, and how is it different? Law of contract, this we have discussed. We have discussed about what exactly is tort. We have discussed about what is difference between law of crime and law of tort. Now let's try to understand that what are the constituents of tort. How we are going to make sure that there is a tort that has happened, and how we are going to make sure that whether there is any remedy that is being available or not. So first we need to understand that all the torts, and this is a question, remember, whether it is torts or tort. Okay, so all the torts is based on the principle of, first we'll try to understand the legal remedy. This based on the principle of ubi just ibi remedium, which means that wherever there is a wrong, there will be a remedy. So there will be a remedy if there is a wrong. So if there is a wrongful act, there will always be a remedy. So this is the main notion, the main principles on which the whole tort is lying. That if there is a wrongful act and that wrongful act is being recognized, then that particular act will give rise to a remedy which will be in the form of yes, this has already been studied in our previous discussion. Let's move forward and let's try to understand what exactly constitutes a wrongful act. So wrongful act is something which by the society as such is being considered as a wrong. So any act which is being considered by the society as a wrong and which has the potential of causing damage and have caused any damage, then that particular particular act will be considered as a tort. So first thing that we need to understand is wrongful act, that we have already studied. Then we are trying to understand what exactly the legal damages, that is injuria sine damnum and damnum sine injuria, that is we're going to study in a thorough manner, but it was very important to understand that what type of damage will constitute a wrongful act. So there are chances that even if there is a wrong that has been done, but the injury might have not been might have not happened. So whether if the wrongful act has done, but there is no injury as such. So there is no injury, but the damage is done. Okay, the wrongful act is done. So obviously, what is the difference between, first we'll try to understand what is the difference between injury and damage. What is the injury and damage? First, we need to understand this. So injury is something which is inflicted. Okay, and because of the injury, there is a damage. So we need to understand that if there is an injury that has been inflicted and then results to damage, that's result to damage, then it is known as injuria sine damnum. It's known as injuria sine damnum. That is injury without damage. And then there is another concept which is damnum sine injuria, which means damage without injury. Now, these are very confusing terminologies for a CLAT aspirants to understand, but I'll try to make sure that you are able to at least understand the important concept which is being applicable. So that is what we are going to study in our upcoming slides. So please be very much clear to what exactly is injuria sine damnum and damnum sine injuria, and what has been considered as the legal damage. So the tort says that there can be two types of damages. A damage that has occurred without injury, and there can be injury also that has not resulted in damages. So these 2 points, even if there is an injury without damage and there is a damage without injury, in both the scenarios, under which condition remedy will be provided and under which condition the remedy will not be provided, the compensation will not be provided. That is what we need to understand in this upcoming slides. Okay, so as we have studied that injury sine damnum, it means injuria sine damnum, which means injury without damage, is where a person's legal right is violated, but the person may not have suffered a damage or loss. So the legal right has been violated, but no loss has happened to that person. In this case, a person doesn't have to prove the damage. It is sufficient to show that violation of legal right, in which case the law will presume damage. So since there was a legal right that was present, because there was a legal right, and infringement of legal right in itself is a damage. So the law will presume that there is a damage that has occurred, that even if without the injury, without the damage, without any loss, that particular person has to be compensated. The best example for injuria sine damnum, for a better understanding, is assault, libel, trespass on land, etc. You know what exactly is assault? So if there is a gesture to hit someone, I show my hand in a slapping posture to hit you. That exactly is what exactly is assault, and that has obviously not caused any damage to you, because I have not put on any force. I have just waved my hand. But this particular action of mine is considered to be a tort and is considered as an assault. And assault is, although the other person might have not have had any sort of damage. There might be no damage because I have not used any physical force. But there is a legal right, and that right is being violated because according to the criminal law, it has been mentioned that assault is a criminal offense also, and nobody should be shown these type of actions because it is considered to be immoral, to be illegal, and that is why there is a chance of the law considering it as a damage. So we don't have to prove when it is injury sign damnum, injuria sign damnum, that there is also a damage that has occurred. Only have to show that there was a legal right which has resulted which has been violated, and because of the violation there is a need of compensating the person. So assault, libel, trespass on land are all considered as torts only. Now, Ashby versus White is a leading case of injurious sign damnum. It is a very important and very interesting case that we need to understand. So, Ashby versus White, let's understand for the facts of the case. Okay. So, Ashby versus White, the main story was that Ashby was a person who was stopped by White for casting vote. Ashby was going to give a vote to a person, let's take the example of X, but White stopped him from the casting of his vote. But any which ways, X won the election. So it was contended that even though there was no damage as such, because in the end of the day, Ashby wanted to cast a vote to that particular person, and the reason for casting the vote was to make sure that X wins the election. So even without him casting the vote, X won the election. So White contended that there was no damage. There was no damage that has occurred. So it should not be like that that I should be held liable, because although I have restrained him from exercising his rights, but there was no damage as such, because in the end of the day, the person has won the election to whom she wanted to cast the vote. But this argument was said that, okay, fine, you might have Ashley might have not suffered any sort of loss, because eventually the person to whom he wanted to cast the vote eventually won. But still, there was a violation of his right to vote. And as we have studied, that whenever there is in violation of the right, then it results to damages. So although there is no real damage that might have occurred, but since there is a violation, it will be construed, it will be assumed by the law that there has been a damage, and the person will be compensated. And opposite of that, injuria time damnum, as we have studied, is damnum sine injuria, which says that there has been a damage without injury. Is when a damage suffered without breach of a legal right. There is no legal right, but the person has suffered damages, is not valid in the court of law. Okay. So in this particular portion, when we were studying it, I asked you that whether injuria sine damnum or damnum sine injuria, under which condition it will be considered that a remedy can be availed, and under which condition the remedy cannot be availed. So the principles, when we studied and when we understood it in a detailed manner, we came to the conclusion that it is only when there is injury and violation of legal right, not injury actually, but there is the violation of legal right, then we can resort to the court to demand justice. But if there is a damage, without any injury, that is violation of the legal right, then you cannot resort to courts. Yes, you cannot resort to courts. So when we are talking about Ashby versus White, this is an important case. Please remember it. Ashby versus White, which proves that if there is an injury without any damage, then also compensation will be given. But if there is a damage without injury, then compensation will not be given. But what if injury is also there and damage is also there? Then what? Then obviously it is the compensation will be given because both the things are present. So our main aim of understanding this point is that what if only injury is present and what if only damage is present? So we came to a conclusion that if injury is there, although there is no damage, because since there is a violation of rights, the person can claim compensation. But if there is a damage without injury, damnum sine injuria, if there is damnum sine injuria, then compensation is not valid in the court of law. Now, this is a case which will help you out in understanding that what exactly we mean by damnum sine injuria, damage without injury. An example so that you can understand, and this particular example will help you out in understanding that even if there is no infringement of legal right, then also a person can suffer a loss. Let's take an example. There is one shop in your society which is doing a very perfect business. It is earning a profit. There is a profitable business going on, and in that particular shop, the groceries is being sold. Now, after a certain period of time, what happens is that there is another person who happened to open another shop of the same grocery store there nearby. And now the sales of the earlier shop was significantly reduced. Now, tell me whether that particular, that was obviously is considered to be a damage because the amount of revenue that they were earning has been reduced. And whether if the revenue has been reduced, whether it should be considered as a damage or not, whether there is an injury or not. This is the main crux, and this is the main understanding that you need to develop. In the real society, you have seen in a society, in the real world, there are many shops of the same nature that is obviously open in the vicinity. But nobody goes to claim because that is something which will be against the fundamental freedom that has been provided to us by the Constitution. So obviously nobody is going to claim that, see, my shop was already running in this particular area vicinity, and since the other person has opened his shop in the nearby office, although it is clearly visible that the other person will suffer the loss, but there is no availability of right. You cannot stop somebody from opening a shop just because your shop is there. It is against the principles of morality. It is against the competitive law that has been there, which clearly mentions that you cannot stop somebody from practicing any sort of profession. And there are various legislations which is showing that you cannot stop somebody from opening any shop in the nearby areas. But in real scenario, if you can see, if there is one shop, let's take an example. So this is a society, okay? And there is only one shop in this particular area, a grocery store. So every person whomsoever are there will be resorting to this shop to purchase the item. Sale will be more. But now let's take the example that in this same society, instead of one shop, there are 5 shops. Then obviously this person, his sales will be significantly reduced. So this person has suffered damage, but no injury. Why? Because there was no right present. So since there was no right present, the injury cannot be said to have happened, although the damage is there. So we need to understand that there can be damage without injury also, and there can be injury without damage also. Majority of the time it is obviously injury with damage and damage with injury, but certain areas where which their injury has happened, but there was no damage, and the contrary could also be possible, that there is a damage, but there has been no infringement of rights, so there is no injury. So whenever we're talking about damnum sine injuria, damage without injury, the main crux, the main thing that we need to retain, and for our CLAT point of view, for our CLAT examination, is that in the case of damnum sine injuria, you cannot resort to court to get compensation. Let's try to understand with the important case, and this case might also be there in your CLAT competitive examination, that there was a school with the case is the name of Gloucester Grammar School Masters case. A teacher opened a school named XYZ to teach grammar to the students. After a few days, another teacher opened a school with the name which named ABC, which was right opposite of XYZ. Okay, now so there are 2 schools. Most of the students from XYZ school took admission in ABC, thereby causing monetary damage to XYZ. The teacher of XYZ filed a suit, but the court dismissed the petition, because even though the damage was suffered, the legal right was not violated. So this is the main crux, that is what we need to understand. That if there is a breach of legal right, then only compensation can be granted. So I suppose the damnum sine injuria and injuria sine damnum is pretty much clear to you guys. Now we will be focusing over the different defenses. I suppose before explaining you the defenses, I would like to show you what exactly are the different types of torts, so that it becomes a little bit easier for you to retain it. That since we have studied what exactly is tort, I suppose the tort is clear to you. The tort means anything, there is a wrongful act which has resulted into any sort of damage. A damage has been done, okay, and that damage has resulted into the violation of legal right. Damage which has resulted into the violation of legal right. And for that, remedy is what? The remedy is unliquidated compensation that will be provided. So the tort has been understood. We have understood what exactly tort is. We have understood what are the constituents of tort is. We have understood that it contains a wrongful act. There is a legal remedy. The legal remedy has been subdivided into 2 parts. Legal damages, which has been subdivided into 2 parts. Injuria sine damnum and damnum sine injuria. We understood that for damnum sine injuria, damage without injury, we cannot demand compensation. But when it is injury sine damnum, we can obviously demand compensation. When you talk about injury sine damnum, we are talking about the case of Ashby versus White, which is a very important case that might be there in your question paper. And then there is another case of robust grammarly school case, where which the damage without injury has been talked about. We have understood that for damage without injury, because without the violation of legal right, there cannot be any compensation. But if there is a violation of a legal right, then obviously the compensation shall be given. After understanding what exactly is tort and what are the constituent of torts, let's try to understand what are the different types of torts and why we are going to discuss the types of tort being, because until unless you are not aware that what type of torts are there, then obviously you will not be able to figure it out, because there is no such legislation which is going to define the different type of torts, like the Indian Penal Code, which has been defining all the offenses that are there. So the four major there are seven type of torts which has been classified into as four major and three minor categories. So three minor categories, if we see, so these are vicarious liability, absolute liability, and defamation. You'll find mentioned these points particularly in the Indian society also. You have defamation that has been mentioned under section 499 of IPC, Indian Penal Code, which defines defamation. You have absolute liability concept. That is what we're going to study in our upcoming classes. And then there is a vicarious liability, the liability to take care. That is what we are also going to study in our upcoming classes. Apart from these three types that we're going to study in detail, what exactly are these torts, there are major torts which are also being subdivided into different categories. So strict liability tort is a tort where which there is a serious accident or serious harm that takes place. If there is serious harm and serious accident takes place, then it amounts to strict liability. There is an important case of Ryland versus Fletcher that we are going to discuss. It means that in this particular tort, that if there is any sort of action which is being done which results in a serious accident or harm, the person will be held liable and it will be considered as a tort, serious accident. Now there is intentional torts. So there are intentional torts, tort which is done with the intention. For example, trespass. For example, mischief. Then you have assault, etc. So all these type of torts which are done intentionally are being covered under the intentional torts. Then you have constitutional torts, which we will be studying, and we will be talking about Bivens notions. What exactly is that we'll be studying in a detailed discussion in our upcoming lectures. And then we have negligent torts. So negligent torts means actions where which it was your duty of, there was a responsibility or we say to duty to take care, which has not been fulfilled or abided by. So we need to understand all these type of torts, and after understanding these type of all these torts, we will be studying about negligent torts. Yes, so there is further subcategory. There is negligence. Then you have accidents, and other different torts are also mentioned. We'll be studying them in a detailed manner. So these are the major categorization, the major categories of the laws. So all these laws we will be studying in details. We'll be studying about this false imprisonment and malicious prosecution also comes under your intentional torts, false imprisonment. And is superficially be covered under the negligent tort also. And then there are different malicious prosecution is also mentioned. Then you have nuisance. Okay, so these are different torts, and their requirements are also mentioned. And what is public nuisance, what is nervous shocks, what is vicarious liability. These are the different uh, type of torts that we are going to study in our upcoming lectures, and we will try to understand. And why is it so that I'm explaining you these torts right away? Because until unless you have a thorough timeline, what exactly are the things that we need to study, it will become perhaps more difficult for you to grasp these knowledge. But once you have understand the timeline, it will be easier. So we have studied what exactly is tort. We have studied what exactly is the constitution of tort. We have studied in the constituents. We have studied the different what are the damages and what exactly is the injury. We have studied about ubi just ibi remedium, which talks about whenever there is a wrong, there will be a remedy that will be there. So based on those particular points, so we have concluded what are the constituents of tort and what are the essentials of tort, and then we have briefly discussed that what are the types of torts. Before dealing with the types of torts that are being mentioned, and we are going to discuss them in detail, we are going to understand what are the different defenses that can be used, and whether these defenses are present to everybody and can be used in absolute every circumstances, or it is something that can be availed in certain torts. So I would like to just explain it to you here only. That is, there is only perhaps one tort. There is only one tort, that is your absolute liability tort. This absolute liability tort, where there is no defense. There is no defense as such. But there are other torts where which you can take the defense of these excuses that has been mentioned, and you will not be entitled to remedy under the law. Okay, so that is what we are going to study in our upcoming lectures. We are going to study in detail what are the different defenses. We are going to study the six. We are going to study the 6 major defenses. And whenever there will be a question that will be put in front of you, which is might be relating in tort, as we have studied in our Indian Penal Code, that all the offences has to be read along with the general exceptions that has been mentioned under the part 6 of the Indian Penal Code. In the same way, it applies to tort also. That even if prima facie it is being observed, it is being depicted that there is a tort that has taken place. But if these general defenses are present, that it will not constitute as tort, and this particular defense can be utilized. So the 6 major defenses that we're going to study is, obviously the first is voluntarily non-fit injuria. That is general doctrine of a person voluntarily giving consent. So if a person has voluntarily given consent, then it amounts to voluntary non-fit injuria. That is what we're going to study. Then the plaintiff's default. If the plaintiff by himself, if the plaintiff by himself doesn't act. So for example, there is a case where which a person enters in the premises of B, and B has kept a lot of poisonous, not poisonous, but rather harmful spikes, and because of which A got injured. So here, what B can use as a defense is that it was by the plaintiff, the person who have suffered the loss because of the injury of being entering into the particular area, that the plaintiff has by himself defaulted, and there has been a tort, that is of trespass, that has happened against A. So A cannot go and claim compensation that B has injured me, because it was the default of A. He has entered into the premises of B, and because of which that harm has been done. So since he himself included in the wrongful act, he has done the wrongful act, then it cannot be taken as injury, but it can be a general defense that can be availed by B against A. The maxim that is being used is ex turpi causa non orito actio, which means immoral cause, no action arise. So this is a very important thing that you need to understand, you need to retain, that whenever there is an immoral cause, then there cannot be action, there cannot be any remedy that can be given or availed by the person because of whose own default that injury has caused to him. Okay, we'll be discussing about this particular case, gun trap case. Then there is inevitable accident. This particular defense has also been mentioned under IPC under section 81 of IPC, that if there is an inevitable accident, then area of road accidents in concerns of where a situation exercised due to care, diligence, and ordinary prudence. But after that also accident occurs, then this cannot be taken as a tort, but the defense can be applied. The act of God. Suppose you have watched the movie of Oh My God 2, Oh My God 1 and Oh My God 2. Both of them are actually talking about act of God. Any act which has been done, which cannot be foreseen, if that because of the natural causes, directly or without the human intervention. This is an important point that you need to remember, that it should not be human intervention because of which the act has been done, but if rather that has been done naturally, then it can be used as a defense in tort. Nicholas versus Marshall is a famous case which talks about the act of God. Then another case is another defense that you can take is private defense, that we have used a little bit of force in order to safeguard imminent threat to personal or safety or property. If there is any danger, threat, imminent threat, first is imminent, it should be immediate. Then you have used private defense, then it can be a general defense against tort. So all these things we will be studying, and then obviously there are things, necessity. There is a necessity. Salus populi is a supreme law, which means welfare of the people is supreme. So if there is a necessity that needs to be done because of which people might have suffered loss, then also it can be used as a defense. Forcible feeding of hungry, striking labor to save her life was held to be a good defense. So this is Lake versus Gladstone, important case when I talk about necessity. Okay. Now mistake. Whether mistake is considered as general defense? Can you say that I was under the mistake and because of which I have done that particular tort? The answer is no. Because mistake, either of fact or law, is generally no defense to an action for tort. When a person carefully interferes with the rights of another person, it is no defense to say that he had honestly believed that there was some justification for the same. Okay, so there cannot be any justification, but a logical and justified reason should be there. If that is not available, then it will amount to mistake, and if there is a mistake, it cannot be taken as a general defense. Actually, we were asked to, this is something that we will be studying in our upcoming lectures. So I suppose you are pretty much aware that the brief of the tort has been explained to you. From upcoming classes, we will be discussing about law of the different type of torts that are there and the defenses. We will be studying in detail what exactly is these defenses that can be used. And after the completion of these topics, the whole tort will be completed. So within 2 lectures, you see that the whole the topic of torts will be completed to you, and you can start practicing those questions, and it will make sure it will be helpful for you to secure a good marks and good rank in your CLAT examination. Because the subject is in short, it can be considered as a very, very specific and very small subjects. There are certain points that you need to remember in CLAT for your from your law of torts, and perhaps majority of the things will be covered within these upcoming two lectures, or maybe one maximum lectures. And once you have been acquainted by the principles, as I've already explained to you, once the principles are clear, start practicing it and be persistent. If you maintain it, if you make sure that these things are there, the three principles which I've already informed you are being followed, nobody can stop you from clearing this particular examination. Okay. So with this, I would like to thank you all for being patiently available to see this video, and I wish you the very best of luck. We'll be meeting in our upcoming videos, which we will be continuing our law of torts, with the types of torts that are there and the general defenses that are there. Okay, we'll be studying about strict liability, absolute liability in detail. With this, I would like to thank you all for being present here. Thank you so much, guys. Bye. Take care.